Welcome to the Explainer. Now, if you're gearing up for the Queensland bar exams, lean in, because this one's for you. We are going to be tackling a really critical and, let's be honest, a pretty tricky part of civil procedure, Rule 389 of the Uniform Civil Procedure Rules. It's all about what happens when a case just goes to sleep.
So, picture this. A dusty file lands on your desk. It's been sitting there for 25 months. That's over 2 years. Now, before you even think about drafting a letter or filing an application, you have to stop. You've got to understand the procedural minefield you've just walked into. Because believe me, one wrong move here could be absolutely fatal for your client's case. Okay, let's get into it.
Here's how we're going to break this down. We're going to cover 6 key areas. We'll start with the basics of why this rule exists, then get into the 2 golden rules you have to know. We'll look at what a proceeding actually is, what happens when you mess up, how you might be able to fix it, and finally, the high-stakes dismissal showdown.
Right, so first things first, why do we even have a Rule 389? Well, it's basically the court's toolkit for dealing with cases that have gone dormant, the ones that are just gathering dust. The rule is there to make sure litigation either moves forward or it's finalized. No more cases stuck in limbo forever.
The whole point of this is court supervision. A sleeping case isn't harmless. Far from it. It can cause serious prejudice to the other parties. Memories fade, witnesses disappear, evidence gets lost. Plus, it just clogs up the court's resources. So, Rule 389 is designed to stop all of that from happening.
Okay, now for the part you absolutely must get tattooed on your brain for the exam. Rule 389 has 2 key triggers. They're both based on how long the case has been inactive. If you can get these 2 sub-rules straight in your head, you are well on your way.
This is it. This is the core of it. For your exam, burn this in. First, you've got Rule 389 Sub-Rule 1. That's your 1-year notice. After 1 whole year of nothing happening, you must give the other side 1 month's notice that you plan to take another step. Then, we have Rule 389 Sub-Rule 2. This is the big one, the 2-year hard stop. After 2 years of silence, the proceeding is automatically frozen. You can take no step, none at all, without an order from the court.
So let's make that super clear. Think of it like this. 1 year of delay is a hurdle. You can clear it yourself by just giving a notice. But 2 years of delay, that's a brick wall. And the only thing that can get you through it is a judge's order. Now, that sounds simple enough, right? But here's where it gets tricky and where a lot of the legal fights happen. It all comes down to the definition of the proceeding itself. So for instance, if the plaintiff and defendant are taking steps between each other, does that reset the 2-year clock on a third-party claim? The answer, you'll see, is a big, fat no. So the official definition in the Act is actually really broad. It says it includes incidental proceedings like counterclaims and third-party actions, but, and this is a huge but, the case law has interpreted this very, very differently for the purposes of Rule 399. The courts treat them as totally separate.
And this is the case you need to know. Medina. This quote nails the key principle. What it means is you have to put on your blinkers. When you're assessing delay in a third-party action, you look only at the steps taken between the defendant and the third party. What the plaintiff and defendant are doing in the main action, completely irrelevant for that 2-year clock.
So both Medina and another key case, Ure v. Robertson, they both hammer this point home. For your exam, you have to think about these things as being in separate silos. The main claim, the counterclaim, the third-party action. Each one has its own clock running under Rule 389.
Okay, so what if someone messes up? What happens if a party just ignores that 2-year stay from Rule 389 Sub-Rule 2 and they take a step without getting a court order first? Well, the way the courts treat this now is a massive change from the old law, and you really need to know the difference. This slide really shows that crucial shift. See, back in the day, under the old rules, there was a case called Perez. It basically said if you took an irregular step and the other side didn't object quickly, their silence could kind of cure your mistake. But now, it's a whole new ballgame. The modern authority is Ure versus Robertson, and it's crystal clear. Under the UCPR, that irregular step is simply ineffectual. It means nothing. The stay from Rule 389 Sub 2 remains firmly in place.
So let's be absolutely clear on this. This is the key takeaway for your exam. If you take a step in breach of Rule 3892, you have achieved precisely nothing. It does not count as a step, it does not restart the clock, the case is still frozen solid, and it's going to stay that way until a judge says otherwise. So, an irregular step is a big nothing burger. But what if you're the one who made the mistake? Is it game over? Well, not necessarily. And this is where another really important rule enters the picture, and it creates some interesting strategic plays.
This is a scenario that happens all the time in practice. You've messed up, you've served a document after the 2-year stay has kicked in. Your first instinct might be, oh no, I have to make that really difficult application for leave to proceed under Rule 389 too. But is there another way? The answer is yes, there might be. And it brings us to another key rule you need to have in your back pocket. Rule 371. It deals with the effect of failing to comply with the rules in general, and it can be a really powerful alternative strategy. A case called Lutheran Church really opened up this pathway. It confirmed you can make an application directly under Rule 371, asking the court to declare that your irregular step was, in fact, effectual. Now, if you get that order, the step is validated, the stay might be lifted, and you could potentially avoid that whole messy, difficult Rule 389-2 application altogether. It's a massive strategic choice to consider.
And that brings us to the final act, the ultimate risk of delay, the thing that keeps junior lawyers staring at the ceiling at 3 a.m., getting your client's case thrown out of court for want of prosecution. In the real world, these two things are joined at the hip. An application for leave to proceed is almost always met with a cross-application to dismiss, and if someone applies to dismiss your case, you'll fire back with an application for leave to proceed. They're two sides of the same coin, and the court hears them together. And here is the brutal bottom line. A failed Rule 389-2 application is fatal. It is lights out for your case. If the court refuses to give you leave, the proceeding is forever stayed, and a court will not just leave a case in permanent limbo. The only appropriate final order at that point is dismissal. All right, let's boil all of that down. If you walk away with nothing else, remember these 5 points for the bar exam. 1. Know the difference between the Rule 389 sub 1 1-year notice and the Rule 389 sub 2 2-year stay. 2. Remember from Medina that you assess each proceeding separately. 3. Know from Muir v. Robertson that an irregular step does nothing to lift the stay. 4. Remember Rule 371 from the Lutheran Church case as your potential escape hatch. And 5. Know that a failed 389-2 application means dismissal. End of story.
See, Rule 389 isn't just about memorizing dates and deadlines. It's about strategy, it's about managing risk, and it's about your fundamental professional duty to keep litigation moving. It's about being able to properly advise your client on their chances of either reviving a sleeping case or, on the flip side, of knocking out a stale one. Knowing the map of this minefield, that is the first and most critical step to getting through it safely.